A very happy Friday the 13th, and welcome to our Elville webinar series. Though it's Friday the 13th, this is your lucky day, as we have a great topic for you, trustee selection and how to choose the right one for you. And our presenter is your very own managing principal and lead attorney of Elville & Associates, Stephen Elville. And I'm Jeff Stauffer, and I'll be your moderator today. And a few housekeeping items as we get started. We always encourage your general questions, so note them in the questions panel, and we'll pause periodically throughout to address them. And more specific questions could be addressed in a discussion with Steve Elville at another time. And yesterday by email, you received the presentation slides that Steve will be referencing. If you didn't receive them for some reason, they're also available in the section marked handouts on your screen to download at this time. And professionals on today's webinar, welcome. You can receive 1.5 continuing education hours for attending. So if you don't have an accreditation or your ID number, please send that to me and I'll be sure to get your hours submitted right away. And everyone will also receive a post-webinar feedback email right after the presentation. So please take just a couple minutes to fill out this brief survey and share your thoughts. We always read and value everything you have to share with us. And a question for you: have you achieved your planning goals, or have those goals shifted over the years, which is not infrequent? Here at Elville & Associates, we want to be a resource to you and your family for your planning needs, whatever it may be. If you're starting from scratch, you have an administration matter, discussing trustee selection, whatever it may be, Steve and his team are here to advise and counsel you every step of the way. So I want to offer Steve and the firm a brief yet proper introduction and share with you and have you understand what is a little bit different about Elville & Associates and our attorneys here compared to some of the other law firms that you may have dealt with in the past. And I hope that becomes very clear to you over the next hour or so. So we're Elville & Associates, founded in 2010 by Steve Elville here in Columbia. We're in the beautiful Columbia Gateway Community Office today. We have several different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning, and different types of asset protection techniques. We have 9 attorneys, 12 staff members, and 3 locations, including our new Rockville office that was opened up late this spring. It's going really well down there. Very pleased with the location and having Lily Humboldt down there leading the office. And our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We focus on education a lot here at Elville & Associates. It's very important. We think it's the right thing to do. We do it in a few different ways. We have planning processes with our clients, and we have different programs to suit every individual and family's needs here at the firm. And also educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We're one of only a couple firms in Maryland to have a client care program accredited by the Client Care Academy in Boston, and I run that program and had my maiden voyage in being a presenter last week for our client care program, talking all about that. I'll send that information out to you later. We also work with the ideals of client education, collaboration, and compassion in mind every day with every client at Elville & Associates. And just a bit about Steve. His work as an attorney for many years has been centered in elder law, special needs planning, and estate planning. He's a member of many dozens of national membership organizations, just to name a couple: National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, National Network of Estate Planning Attorneys, Wealth Council, you name it, he's part of it. Steve always works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. And Steve is a very seasoned speaker, always presenting at many webinars, workshops for businesses and their employees, different conferences. We talk at the Brain Injury Association of Maryland conference each year, and we're doing that again this April 3rd, and also different continuing education events. And Steve was named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. We may have an announcement about 2025 on December 16th on Monday, so stay tuned for that. And he also had a feature story written about him in a national Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charity that Steve founded in 2014 I'm very fortunate to be a big part of. I'm looking over at my desk here. I have about 20 to 25 instruments that I have to deliver to some schools in the next few days, and that's one of my favorite things to do. I just ordered 6 new Alcaraz guitar sets from our friends at the band shop the other day from a nice donation we received by a client. And I'm going to be delivering those to the Baltimore Classical Guitar Society. So lots of things going on with our charity. I'd love to speak with you a little bit further if you're interested in donating or getting involved. But for now, we have other things to cover, including trustee selection. We have a brief poll I want to run, and I'm going to launch this poll. And it's simply, what has brought you to today's webinar? And select the response that best suits your situation. And the first one is, I'm a grantor. I've established a trust before, or I've been or am a trustee of a trust. I'm the beneficiary of a trust. I'm considering establishing a trust, or I'm an advisor here to learn to better serve my clients. So make the choice that best suits you, and appreciate you being here today on a chilly Friday. Most Fridays are good regardless of the temperature, right? What do you think, Steve?
I think I know now, Jeff, why you're wearing a red shirt. And I think I also know why you have an SUV, because you have all those instruments to haul around. So you're basically
Yes.
Santa, I think.
Yeah, I feel like it when I go around this time of year. It's a good feeling.
Yeah, and I noticed you have a couple of big instruments back there. I saw some cellos back there.
I've got cellos, I've got guitars, I've got French horn, 2 saxophones, trombones, I have some flutes, different violin sizes, clarinet, a couple accessories, some bows in different cases, lots of different things. So it's all thanks to donor support. We can't do it without donor support.
Hopefully it'll all fit in your car, Jeff. All right.
Might be 2 trips. All right, so 35% say I'm a grantor, I've established a trust before. 14% say I've been or am a trustee of a trust. Nobody here says they're the beneficiary of a trust primarily, is the primary answer. 38% say I'm considering establishing a trust. And lastly, 14% are advisors here to better serve their clients. So Steve, I'll turn it over to you, and let's get you to be the presenter.
Thank you so much, Jeff. Wow. All I can say is thank you for such a wonderful introduction, and looking for that button, Jeff, so I can take over.
Let me take it back and then give it back to you.
All right, sounds good. There we go, I got it.
All right.
And I'm going to get my screen up and start my slideshow. And good morning to everybody, and happy Friday morning to you. And wow, it's so good to be with you here this morning on this chilly morning. We've got the heat going here in our Columbia office. Wherever you are, I'm wishing you happy holidays. And we've begun on time, and I promise we're going to be efficient and end on time. And Jeff is an expert moderator. He will take questions that you may have, but we do encourage your participation. We know it will benefit you and others. So if you have a tablet or a piece of paper or computer or whatever you're using to take notes, we want to give you something substantive here today. We know you're very busy, so we appreciate you being here. It's my privilege to educate you again this morning and participate in education. And I just want to say that as we start this webinar this morning, it strikes me that at this time, here we are, Friday the 13th of December, right before 2025. It's hard to believe. It's hard to believe the new year's coming. It's hard to believe the holidays are here. And I think the main thing to remember, despite all the world news that we're constantly inundated with, all the political changes, all of the upheaval in our world, we are still able to choose. We have a lot of choice. And that's what this is about this morning, is how to choose and how to understand that you have opportunity to choose. The laws are very flexible these days. The laws are very broad. And what I hope to do today is give you I guess a foundational starting point to be able to think about this subject of trustee selection, which arguably couldn't be possibly more important than any other subject, or maybe is more important than any other possible subject about estate planning, other than selecting, your agent for your power of attorney and so forth, or your healthcare agent. But this is right up there and possibly would be the most important thing to you. So we're going to get started. Thank you for being here. And again, happy holidays to everyone. Of course, this is not legal advice. We're not in an attorney-client setting or an attorney-client relationship, but this is high-level education. And if we ever do meet in a conference room setting or at a home, at your home, we are in an attorney-client privilege situation and all information would be confidential. We're going to talk about what trustees are and what their responsibilities are. Now, some points of this discussion are very fundamental and very elementary. Someone once told me that I need to communicate on a very fundamental level. So that's what I'm going to try to do today. And I may be telling some of you things you already know, but I think sometimes we get the most out of it if we are very, very fundamental. We're going to talk about the types of trustees and their characteristics as you think in terms of trustee selection. What are the advantages and disadvantages from a macro level of the different types of trustees? What is the perfect trustee if we could find that person or that organization? And this would set a benchmark for the selection process. Why is trustee selection so important? Well, I've already mentioned a few of those things, but we're going to get into that. Trustee succession, this is an issue, right? Not just trustee selection, but trustee succession and the design of the plan. And one of the interesting things, and I think one of the most positive things about today, as we talk about this subject, is that you do have so much opportunity between now and the rest of your life, or now while you're healthy and well, to constantly be revisiting this subject. You are not necessarily locked into something. You have opportunity to continue to review, to continue to change your mind, to continue to design a plan. We're going to talk about trustee roles and the foundational documents of wills versus trusts. Now, of course, there are advanced trusts and those kinds of things, but we're going to be talking at a very foundational level, wills versus trusts and the different roles. What are some of the reasons to consider appointing a corporate or independent trustee? And why we should be concerned, I should say, about trustee risk, the successor trustee risk. That's part of that succession discussion. So let's get right down to the fundamentals. What is a trustee and what are their responsibilities? Well, as you can imagine, there is a document which we're going to talk about, what is a trust, but the role of the trustee is to administer that trust. That trust is a foundational contract. It is an agreement. And the trustee needs to read it. First of all, we want our trustee to always read the document and then to reread it in the future. But sadly, many trustees never really read the trust more than just in a cursory way. So it really takes some dedication to be able to administer the trust. We have to follow the terms and provisions of the trust, and that's what you're looking for. Someone you know that will actually do that. Someone who will keep accurate records. Someone who will account to the beneficiaries. Yes, the beneficiaries are entitled to information and they're entitled to an accounting and so forth. So many of these things we're going to be redundant on today as we talk about them. There's going to be some redundancy on purpose. The trustee has to make distributions, and these are either mandatory distributions or they're discretionary distributions according to what? The terms of the trust, of course. The trust instrument. Trusts can make investments and must make investments in a prudent way unless there is a waiver of that rule. So the trustee's role is to preside over trust investments. Yes, communicate to the beneficiaries, not just provide information or accounting to them, but to communicate with them and make sure that there is this path of communication. And yes, Uncle Sam cares about trusts. A trustee must ensure that all tax filings are complete and that they're on top of that. This is an annual process. And on top of that, the trustee has to manage the assets, meaning they have to manage the assets, not just in a financial investment situation. They have to take into consideration the income taxation of trust, which is a whole subject in itself, which we won't delve into very much today. But this is just part of the role of the trustee and setting in your own mind, what is the criteria? What is the benchmarks that I should be setting? Well, these are some of the fundamental roles. All right. Now let's talk about the basics of trusts and definitions. So we talked about just a second ago, maybe a 15-second definition, but let's get right back to this trust definition. What is a trust? Well, it's a relationship. It springs from an agreement between a grantor. Now that is the modern term. You heard Jeff mention that. But in the old days, and when I was a new lawyer, many times grantors of a trust, the person who's creating the trust, would be called a donor or a trustor and so forth. So the different terms of art. But today the term of art is grantor, the creator of a trust, and that trust has a trustee that provides for a beneficiary. So the parameters of the trust are described or prescribed in the trust document. So the trust document is created in accordance with applicable law. So for example, Maryland law, or our neighbors in Delaware, Delaware law, Virginia law. And the parties to the trust, we're just going to reiterate again, the grantor, in the old days, a settlor or a donor or a trustor. That's the person creating the trust. A trustee, which could be an individual person or corporation that is accepting, who is accepting the property that's placed in the trust. This person has a duty, a fiduciary duty, to manage the property for the benefit of the beneficiary as what? As prescribed or directed by the grantor of the trust. Now I'm going to stop for just a second and give you a little gold nugget. Those of you who may not have heard of this, there's something called a letter of wishes. A letter of wishes, which we're happy to send you a sample of. So when the trustee has accepted the trust property, they're going to manage the trust property for the benefit of a beneficiary. They are guided by the terms and provisions of the trust, but they also could be guided by your personal informal wishes, your informal guidance set forth in a letter of wishes. We'll talk about that a little bit more, and I hope to make sure that I circle back to that. And of course, the beneficiary is a person or persons, could be more than one person, for whom the trust is intended to benefit. So how they get distributions, when they get distributions, and for what the trust property may be used for is all described in that agreement. Now, continuing on a review of basics, a revocable trust is something that many of you may have already. If you don't have a revocable trust or don't know what it is, or even if you do have one and need to be reminded what it is, this revocable trust is the very, very most basic trust. This trust is a substitute for a will. So a revocable trust can be amended, modified, or revoked. And the most common form is this revocable living trust that many of us know of and deal with all the time. And for the advisors that are on this webinar this morning and any other special guests that may be familiar with this, this is the most fundamental of all trusts. It is a substitute for a will. In the most foundational way of thinking of things, in basic estate planning, we have wills or revocable trusts. A revocable trust is a substitute for a will. All right, and it's an extension of the grantor. So as such, the income of the trust is passed along to the grantor. So if a person is a person with non-retirement assets, such as cash, investments, brokerage accounts, and they obviously have a social security number that identifies their assets, but now they move those assets into a revocable trust. That revocable trust is still identified during that person's life, still identified by their social security number. So nothing has changed. That person's tax filing does not change. Their 1040 does not change. And the income of a revocable trust is taxed to the grantor. And that's why we're going to see this in a few minutes. This is called a grantor trust. A revocable trust is a grantor trust. Now, an irrevocable trust is a trust that's not supposed to be able to be amended or modified or revoked unless it's through a court. And that was what it always was. But now, in the new era, we have many ways of, don't laugh, changing an irrevocable trust, even though it's irrevocable. So if that doesn't make any sense to you, you're not alone. So generally speaking, an irrevocable trust is going to be taxed as a separate entity, generally speaking. However, if it is a grantor trust, which we're going to talk about, then that separate entity would not be actually taxed as a separate entity. It would be taxed as if the grantor was paying the income tax. So we have revocable trust, we have irrevocable trust. For those of you who would like a simple, maybe sometimes too simple of a definition, but I think very, very effective definition of the difference between a revocable trust and an irrevocable trust, here is my definitions for your benefit. A revocable trust is a substitute for a will. That's all it is. There's nothing magical about it. It does not protect assets. It does not provide any necessarily big tax benefits of any different than a will. An irrevocable trust, I would like you to think of as a trust for a special purpose. It doesn't mean it's a special needs trust, even though a special needs trust can be an irrevocable trust. What I mean is an irrevocable trust is a trust with a special purpose. It's a life insurance trust or a charitable trust or a residence trust. We could go on and on. So revocable versus irrevocable. An irrevocable trust is a trust with generally with a special purpose. Now, the traditional revocable trust is just like I said, it's for the management of property, the avoidance of probate. Now, as you think through who your trustee is going to be, we're going to see the role of the trustee with wills or trust. Here we start to see that a revocable trust is just a fancy will. It is a upgraded kind of trust or estate plan, I should say, that avoids probate. A good use of this is if you have a out-of-state property like in South Carolina or Delaware or Florida. This can put your second residence in this trust. Now it avoids probate, subject to certain rules we have to be aware of in places like Florida that have certain homestead exemptions that we don't want to mess up. The disadvantage of a revocable trust is it's a little bit more involved up front than a will. So that's what a traditional revocable trust is. Now, as we start thinking about irrevocable trusts, perhaps one of the irrevocable trusts would be a trust that we leave a child or niece or nephew or someone at our deaths to protect them from divorce or protect them from the substance abuse problems, God forbid, that they may have. Or simply we don't want them to be in charge of their own trust. So there might be an independent trustee. And perhaps that trust would be a trust that goes forever and protects all the descendants down the bloodline. Or maybe it's a trust that ends at a certain age. So these are all the different kinds of common trusts. And as you think through who would be the best person to be my successor trustee if I were incapacitated, or if I died, or if I left a further trust for other loved ones, who would be the best person to be that trustee? All of this information is foundational. As we continue to think about these common trusts, there might be a person who doesn't really have a lot of problems. They don't have problems with creditors or money management or substance abuse, or they don't have any kind of disability. This person could actually be protected in a trust, through a trust, a further trust, an irrevocable trust, but this person could have some beneficiary control over their trust. So a lot of the discussion about design as you think about trustees or you rethink trustees as you go through your life, it really has to do with goals, G-O-A-L-S, goals. And all planning is goal driven, or should be. So it shouldn't just be, here's a set of parameters because a lawyer said so, or a financial advisor said so, or a CPA said so. It should all be coordinated with your planning team, but it also should be goal driven. So as you look at your documents and you know what your goals are, or you work to know what your goals are, through a series of counseling sessions or education, like Jeff said, or epiphanies that you may have through webinars like this one. As you think about this, your documents can evolve. Your documents have a lot of possibilities for flexibility, for avoiding creditors for beneficiaries, if that's one of the goals, for protecting our children from divorce losses, and so forth. Now, as we think through these things, we have to remember that even if we do provide asset protection for beneficiaries, there are exception creditors. Exception creditors include Uncle Sam. Exception creditors include alimony obligations and child support obligations, except in Nevada, where I understand there are no exception creditors. But these are the fundamentals that we have to think about. And as we install or appoint trustees, this is what they're dealing with. This is what we want them to be educated about, whether this is an independent person or your child. A special needs trust is a common trust. There are two types. There is a third party type. This is the type where someone, a loved one, leaves assets for the benefit of a person with disabilities. This is the most common trust. This is the most powerful and bread and butter type of trust for special needs planning. The other one is a self-settled first party trust. This is where the person comes into money through no fault of their own. That person has disabilities. That person could have had a birth injury or other settlement or car accident, or maybe they just were left money from a well-meaning relative who left them money and they shouldn't have had that money in their own name. There are ways of dealing with this, and these are some of the common trusts that your potential trustee needs to understand, at least the foundational principles of some of these trusts. All right, and as we wrap up on this particular subject, as I go to the next slide, again, we want to just reiterate and be intentionally redundant, as Jeff and I often say. The trustee is the person or independent person or corporation that accepts the trust property, manages the trust property for the benefit of a person who is the beneficiary. And the beneficiary is the person for whom the trust is intended. And the trust is going to have parameters for this person, the trust terms and provisions, plus any kind of memorandum of intent or letter of wishes that the grantor may choose to provide. All right, let's take just a breath and grab your coffee because you may need it for this. Jeff, do we have a question? I just wanted to think through this.
Absolutely. We sure do. Question is, what to do when a close friend of a grantor is trustee who refuses to release funds to the beneficiary at a clear point in time and twists language to protect himself? Guidelines / consequences to be put into the trust? Question mark. We had to go into circuit court to expel him.
Yeah, thank you for that question. Well, obviously we can't provide legal advice over the webinar, but it sounds like there might be a trust that has clear parameters, that it ends at a certain point. The person who's the trustee is refusing to make outright distributions, and I don't know whether they have valid reason. Doesn't sound like it. And the trust instrument itself may have some kind of what I might call backdoor provisions that allow a trustee to still hang on to the money. So you have to be careful about that. But it does sound like, all things being what you've described, that perhaps if there is not a trust protector provision in that trust, that maybe the only thing you're going to be able to do is seek removal of the trustee through the circuit court process. And if you have to do that, I apologize and feel sorry for you that you would have to take that action, but that may be the only thing. But I would first look at the trust instrument, and we'd be happy to discuss that face-to-face or to review the trust instrument. So good luck with that. Thank you, Jeff. So now let's dive right into this and stay on time. It's 10:30. We want to make sure we end on time. What is a grantor trust? Well, a grantor trust, I'm going to relieve you, if you will just accept what I'm saying, you'll relieve yourself of a lot of worry. Lawyers get all mixed up about this. non-lawyers get all mixed up about this. A grantor trust is a trust where the grantor pays the tax. So I want you to write down the grantor trust rules are in IRC, Internal Revenue Code, section 671 through 678. These are the grantor trust rules. So through these rules, the grantor of the trust can be the person who is deemed to pay the income tax. In other words, if there's $25,000 of income or $4,000 of income of a trust or $100,000 of income, all that income is attributable to the grantor to pay the income tax on that, in those interest or dividends. So a grantor trust is a trust where the grantor pays the tax. A non-grantor trust, and let me give you an example. Remember, by the way, a grantor trust is a revocable trust. But when the grantor dies, the revocable trust becomes what? Irrevocable. And now it has to have a tax ID number, and it is taxed as a separate entity. But a grantor trust is a trust where the grantor pays the income tax. Now, a non-grantor trust is a trust where the trust pays the income tax unless the trust income is passed out to the beneficiary. So non-grantor trust, and a good example of this is a non-grantor trust is a trust for children. You die, you leave a trust for a child or grandchild. That trust is going to be a non-grantor trust. It's a trust at death. It's a trust that has its own tax ID number. It's a trust that pays its own tax, and it has to file a 1041, a trust income tax return. That trust is going to pay its own tax unless the income is passed out to the beneficiary, which oftentimes, most of the time, it is. Why? Because non-grantor trusts are going to pay income tax at a much lower threshold. The trust only has to have income of $15,200 to pay its own, to pay tax at 37%. So yes, we have compressed very onerous trust tax rates, which is why non-grantor trusts have to be managed. Now, certain trusts have to be non-grantor trusts, like that trust for the child that I was just talking about. That was a trust at death. Certain other trusts have to be non-grantor trusts, but many trusts can be grantor trusts. So for example, a life insurance trust could be a grantor trust and so forth. So they're a spousal lifetime access trust, a SLAT, which is a advanced planning tool for estate tax avoidance. That is a grantor trust. So there's all kinds of ways to understand the difference between a grantor and non-grantor trust, depending on the goal and depending on the use of the trust involved. This is something your trustee needs to have a foundational, fundamental understanding of. Now, it's very confusing. Does your trustee have to be an expert on grantor versus non-grantor trusts? The answer is no. But what they do need to do is they do need to hire professionals, avail themselves of professional advice, and not be going it alone. And as long as they do that, they will understand grantor versus non-grantor trust. They'll understand the tax returns that have to be filed for the trust, and they will also stay on the straight and narrow path with the trust filings and management. Remember that last bullet point at the beginning of the presentation? The management of the trust taxation. That's really what we're talking about here. Now, in 2014, Maryland got up to speed with the rest of the country, and even went ahead of some of the other states by having something called the Maryland Trust Act. Your trustee has to understand that they have duties and responsibilities. Why is this so important? Well, for the obvious reasons, they have duties and responsibilities. But the other thing is, they could be embarrassed. They could be removed. They could suffer legal action if they don't follow the terms of the trust and if they don't understand the law. So if a person is a qualified beneficiary of a trust, that means that the trustee has to provide notice to them. There are notice requirements upon the creation of trusts. There's notice requirements about appointments of new trustees and so forth, and these cannot be waived. So this is where an unwary person who's a wonderful person, a good trustee, can really get themselves into trouble. And hopefully they wouldn't do that. And that's why we recommend that trustees have professional guidance and are acting under, the advice of an attorney and a planning team. Remember that qualified beneficiaries in Maryland have rights. They have a right to a copy of the trust. They have rights to annual accountings, and they have the right to reports, and they have rights to know what the trust assets are. There is a belief among some people that there is such a thing as a quiet trust in Maryland, and that is not true. Maryland law under the 2014 Trust Act seems to indicate that notice could be deferred to another person, like a personal representative, but that is not a quiet trust. So even though there might be another person appointed to receive notice for a qualified beneficiary, if they could not receive the notices themselves, that person could still be sued by the beneficiary. So there is no such thing as a quiet trust in Maryland where the beneficiary does not get information and notice. There is such a thing as a quiet trust in Delaware and some other states, but not in Maryland. So beware that trustees have responsibilities. And one of the things I want to throw out here that I think is very important for today is to understand that, in my opinion, Maryland law has really, really become much better. Since the 2014 Act, and now with many of the estates and trusts provisions that have, or laws that have been passed since 2020, Maryland is quite up to speed with many other competing states. We have a new decanting law, which means that trusts can be amended and they could actually be changed to new trusts if long-term there are changes in the world that affect the beneficiary, changes in the world that affect trust law. So Maryland was really behind many other states, and I feel very confident in telling clients or potential clients and advisors that we have a lot to be proud of about Maryland law. And we don't have to look to the laws of other states like we used to be able to avail ourselves of wonderful trust laws. So we have other issues in Maryland, such as issues relating to the quality of long-term care and other issues. But with regard to trusts and estates, I think Maryland is doing an excellent job. So with that said, we're going to keep moving. What is the role of a financial advisor in a trust where you've chosen a trustee? What is their duty with regard to financial advisors? Well, unless a trustee is a professional advisor, they have no business, in my opinion, investing the trust assets. That's not to say that I don't see that. That's not to say that there are some people who wing it and still come out smelling really good, but they're not supposed to do that. So a person who is a trustee is supposed to, one, hire professionals, hire professional tax advisors, hire professional financial advisors. When they hire a financial advisor, what is that person supposed to do? What is that company supposed to do? They are supposed to recognize that the trustee is a fiduciary, and the trustee is only supposed to be investing with financial advisory firms that are fiduciaries, and they are supposed to get what? An investment policy statement. So your trustee is supposed to get an investment policy statement that they can hold up in their hands and say, I am doing everything I'm supposed to do as a fiduciary. So that's what we want with this very high level of fiduciary responsibility. Now, the financial advisors, and many of them are on this webinar this morning, these are professionals. They are going to open accounts, make sure there's plenty of cash available, make sure there's a money market account attached to the trust account, make sure that if there's mandatory income, that it's going to be paid out at a certain time. They're going to assist the trustee after someone dies in stepping up the basis of non-retirement assets. They're going to move over assets to the various trusts. They're going to just make sure that everything is properly managed in coordination with the trustee and with the CPA. So this is the role, this is the viewpoint of the trustee and the financial advisor. And as far as managing the trust portfolio, the prudent investor rule says that this trustee is responsible for managing this trust property as a prudent person would. They have to exercise their financial fiduciary responsibility, and unless there is an exception and a waiver of the prudent investor rule, the trust portfolio must be allocated appropriately. So does the beneficiary have a lot of cash needs? Whatever that is, we need to look at the long term and the short term, depending on what that beneficiary's needs are. That is the role of the trustee, not just to abide by the trust terms and provisions, not just to abide by the informal wishes of the grantor through a letter of wishes, but also to work with an advisory team that helps them do what they're supposed to do with this trust for the benefit of the beneficiary. Now, Jeff, I thought you had found some pictures of perfect people. You must still be looking.
I am. They turned out to be not as perfect as I thought they were.
I got you. Well, thank you for being honest, Jeff, that you still haven't found a perfect person. Well, if we do find that person, I want to put their picture up here, their photo, because we're looking for trustees that are perfect, okay? These are people who, let's start at the lower left concentric circle. These are people who are accountable. These people keep accurate records. They inform beneficiaries. They comply with their statutory duties and never fall behind on that. They manage the investments. If we go to the right concentric circle, they have hired professionals as fiduciaries. They have an investment policy statement. They have a fundamental understanding of taxes, but they sure don't try to do it themselves. They hire CPAs. Now, granted, CPAs today are tough to find. It's very difficult to really connect with a good CPA. There's a lot of CPA shortages in this country. So we want to get some real professional advice about where to find the right CPA, but they certainly don't want to be filing the taxes themselves. And if we go back to the top, we see that if the person has some disabilities, or if it's a special needs person, a disabled person, we want to advocate for that person. And even if the person is not a person with disabilities, what should we have up in that circle? We should have something that says that the beneficiary is going to just basically their needs are going to be accounted for. What kind of person is this? What are their needs? Are they being communicated with? And are they, is the grantor's intentions being carried out? That's what we really want to say to ourselves. So Jeff, we'll continue to look for that perfect trustee, and thanks for continuing the search. Now, why is trustee selection so important? Well, for obvious reasons, that we're talking about today, but also because trusts can last forever. Maryland abolished the rule against perpetuities. That's the old English law that said trust can only last a certain amount of time. Now, there are certain people in Congress who want to kind of go backwards there and say trust cannot last forever, but so far, most states say trust can last forever. Trusts are more portable than ever. The trust that you establish under Maryland law could be moved. It could be moved to another state law if that state law was more advantageous. States are in competition for a more advanced trust business. Many of you may not know this, but asset protection states like South Dakota, the last time I checked, have trillions of dollars of assets under management in trusts that are advanced trusts, much more so than any other state combined. So states are in competition for trust. Some states have certain trust laws that are more advantageous. Beneficiaries, like your children, grandchildren, are likely to change their residence, their domicile. Many of you on this webinar have kids that are living in all kinds of different states, and you wish they were closer, but they're not, but they're happy, so you're happy for them. But they can change where they live. Trustees have options. Let's switch to this one now. This is a little bit negative, and I apologize. Trustees have the option of not serving. So you have to be careful when you're selecting trustees, because maybe the person actually won't serve. I've had an experience in the last 2 or 3 years where an individual trustee said they would serve at a critical time. They were asked to serve and they refused. So we have to have flexibility for changing circumstances, which is the bottom bullet point. And this is also true of corporate trustees. You can select a corporate trustee, but remember, a trustee, whether they're individual, independent individual, or a corporate independent trustee, those trustees do not have to serve. There's no obligation. And you must build in, if you can, we want to build in flexibility to be able to deal with that, if that arises. So as we are getting toward the end of the presentation, or the latter part, The trustee selection process for you or your family, or if you're a professional on the call, your clients might be easy. There could be just a very simple mental checklist: children, siblings, uncles and aunts, other people. So maybe this is easy, but wait, we want to just put the brakes on there for just a second. We want to talk about what is the difference between an interested person and an independent person. Well, I was reminded of this. I prepared for our client care program event last weekend and the 2 weeks before that, and I was rereading Maryland law, and I had occasion to look at some other state laws just because it was something that happened with a certain relationship I have in a certain peer group I belong to, and we were looking at North Carolina law and some other laws. And there is a big difference, not only in the world of trusts and estates, but in the world of the IRS and the code and in state law about interested versus independent trustees. So as you think about your purposes and your goals and what you're doing with a particular trust, what are you trying to do with that? You're going to think about, should the trustee be interested, like a relative of mine, my child? Should my child be the trustee of their own trust? This is a big decision because the child being the trustee of their own trust may not accomplish the asset protection that you're looking for. It does provide, let's say, a modicum of asset protection, a moderate amount, but it does not provide the kind of asset protection most people are looking for, versus an independent trustee. An independent trustee would, by definition, provide much more asset protection if that was the goal. So there could be management concerns or asset protection concerns, protection concerns of all kinds. This is the discussion of independent versus interested trustees. So it's not as simple, depending on the goal, as we might think, but sometimes it could be simple. And this is best done in counseling sessions, right? Elville and Associates does a lot of meetings and review and education for those clients that are looking for that. And we are here to provide that kind of counseling. We help you visualize, we help you discuss these things until you have an epiphany of what is the right thing to do. And that could involve interviews with trustees if these were other than just interested persons in your life. There could be conflicts that arise by appointing an interested trustee. So we have to talk about that. And independent corporate trustees versus independent individuals. That's another subject. If we're going to have an independent trustee, there are many choices on the corporate side and some choices on the individual side. Having an attorney or having a friend or having someone serve as a trustee versus having a bank or corporate trustee, or your broker dealer may have a corporate trustee relationship that could be very advantageous depending on what you're trying to accomplish. So there are advantages and disadvantages. These need to be hashed out. And then just checking my time real quickly to make sure we're on time. This last bullet point is worth spending 1 or 2 minutes on: the trust protector. So Maryland calls this the trust advisor, but nationally this is known as a trust protector. This is a special fiduciary that you can appoint that would have certain powers to deal with situations that in the past there were no flexibility provisions. So now you, through a trust protector, can have flexibility. And this is something that takes a little bit of getting used to give a special fiduciary the power to change trustees, or the power to amend the trust administratively, or to do other things, such as compel an accounting or take other action. So trust protector is a special fiduciary. I strongly recommend this for most people. And this is something to really think about as you think about your trustee selection, but also having the peace of mind that you can include a trust protector. You also have peace of mind when you learn how Maryland law has evolved and how trusts can now have more foundational flexibility. And this is all, in my opinion, that we can share with you if you need further counseling about that. So when we have an interested trustee versus an independent trustee, there are different standards of distribution. And that is way beyond today's discussion, but just accept, if you would, that if we have a different standard of distribution, depending on whether it's an interested or independent trustee, this makes a difference in asset protection levels, a big difference. So this is something to be considered. Different points of view, different levels of objectivity, different levels of oversight. For example, independent trustees that have a fee schedule, or like a trust company or a bank, they must provide a fee schedule to the Secretary of State of Maryland. So there are different levels of oversight, but also different approaches that these trustees have to managing assets for beneficiaries, and practical considerations of all kinds, depending on where the beneficiary is, what kind of support do they need? Is this the kind of trustee that can take care of a beneficiary of the type you're providing for? We talked about the trust protector. I got a little bit ahead of myself, so let's just be redundant. This is a special fiduciary. It's been around since the early 2000s, if not before. In Maryland, we've had a trust protector law since 2014. It's basically a power of a special fiduciary to be able to direct or tell a trustee what to do with certain parameters, okay? And the trust protector has to serve as a fiduciary. When you appoint a trust protector, or when the trust you're dealing with has a trust protector, that trust has much more flexibility than it would have otherwise. Although, even if a trust does not have a trust protector now, there is still some very nice flexibility in the law to be able to maneuver if a trust becomes unsuitable for someone, or trusts need to be updated over time due to changes in the law. Now let's talk about, in the last several minutes that we have, let's talk about the role of a trustee in a will plan. Now remember, a will plan is, we have a will and we have financial powers of attorney and advanced medical directive. But let's focus on the will. Now, when someone dies, if they have a surviving spouse, there is either going to be outright distribution in a simple will, or there's going to be trust distribution, either to a marital trust or what we would call a non-marital trust. And we're not going to get into those distinctions too much today, but if there's a trust for a surviving spouse, we have to have a trustee. Is it going to be the surviving spouse, or is it going to be the surviving spouse and the children? Is it going to be an independent trustee? There could be, bullet point number 2, there could be a trust for young beneficiaries. Many of you have seen this over and over again. A simple will that has a trust for people that are 25 or 30 years old or under 35 years old. We need a trustee for that. Or there could be a trustee of their own trust. So let's say that the testator, the person that creates this will, dies. Now there is a trust created for someone else. That person could be, under Maryland law, they could be trustee of their own irrevocable trust. That's for their asset protection. And as I mentioned a few slides ago, there is pros and cons of this person being their own trustee. Or there could be a trust where there is an independent trustee. So this will creates this trust for this person, and now there's someone else, a third party, other than that person themselves as the trustee. So giving you a visualization as you think through wills, basic wills, these are the various situations where there could be a trust. I would say one other thing that could happen here, this modern approach could be in the will. There could be a standby supplemental needs trust, just in case someone was disabled and there was never any planning for this person, although there could have been, but there wasn't. There can be a standby supplemental needs trust under a will. This would be another situation where there would be a trustee of a trust. Now, if you have a revocable living trust, I'm just going to take a drink. We now know that you have a living trust. You have a trust that actually exists as that very basic grantor trust during your lifetime. So if you became incapacitated, you had not died, your successor trustee steps into your shoes. So there you have a successor trustee role, but you're still living. You are incapacitated, okay? But now at the death of the grantor, your death, let's say, now your trust has to be administered. So remember, in a will, there would be probate. That would be the probate process, and then a trust would be established. Well, here, the revocable trust at your death has to be administered, then further trusts are created. So we have a revocable trust living successor incapacity trustee. We have a revocable trust successor trustee at the death of the grantor to administer the trust. But now, starting with bullet point number 2, you see that the rest of these trusts are very similar to the trusts that can be created under wills. It's different, but now we've got a trust that creates a marital trust or a bypass trust, which is this non-marital trust. Or we have a revocable trust that's fairly simple, that creates a temporary trust for others, or a standby supplemental needs trust. Or we have a revocable trust, which many people have today, that will leave further protective trusts for children. We call those irrevocable spendthrift trusts. And those trusts are the trusts where the child or beneficiary can be their own trustee, or they have a third party being the trustee where they have more asset protection, especially if it's an independent trustee. So as I go back to this slide very quickly, we see in wills and trusts, there are different roles of trustees. Now, of course, there are more advanced trusts like life insurance trusts or residence trusts, and those kinds of things. But this is the basic foundational understanding of what to think of in your trustee about how will they understand this, how will they function, how will they step into their role and carry out their fiduciary duty. Now, we talked a little bit about a corporate trustee, but let's just get into this a little bit more. Corporate trustees such as trust companies, banks, and so forth, credit unions that have trust company relationships. Well, many of you may consider this to be an advantage. There's experience. They're going to manage the assets. They are really compressing prices. I have to say that one of the things I've seen in my career is the price of, or the cost of appointing and using a corporate trustee seems to be coming down. There's a lot of competition. These corporate trustees are regulated by state and federal government. They are generally reliable. They are objective. They are a good source of referrals to support the beneficiary many times. They are considered to be an entity that has longevity. And for some people, or for many people, this is peace of mind. So if you are in a wonderful relationship with your financial advisor and you're looking for them to continue to manage the assets, they could have and very well may have and probably do have a corporate trustee relationship that you could utilize to make sure that your financial advisory firm that you love continues to manage your assets for the benefit of your child or other beneficiaries in trust. But if you are considering this kind of thing, we are here to talk it out, to help you interview trustees and to ask the right questions. And sometimes the first thing to do is to talk to your financial advisor and see what the relationships are that they have, because you're going to want them most likely to continue to manage your assets. Now, what is this successor trustee risk as we really start to wrap up? Well, as we appoint individual trustees, right, we're all getting older, health may deteriorate over time. Most trusts would not require a bond. By far, 99% of trusts would say, my trustee does not have to post a bond. Well, why? Bonds are very expensive, that's why. And, you know, generally we trust our trustees, but we don't feel like they have to post a bond. So that's a waste of money, but we have to understand that when they don't serve with bond, there's really no protection. And obviously they're fiduciaries, they cannot misuse the trust funds, but it is a little bit of a risk. Other life changes, the trustee could get divorced, or the successor trustees could be unavailable because they have bankruptcy or creditors, or unforeseen circumstances, which sometimes in recent years I have actually seen myself in dealing with certain trusts. They might be disconnected with the needs of the beneficiary. Maybe they're having issues in their own lives, or maybe they're just not good trustees. So we want to have a trust protector in there, a mechanism to be able to change trustees. And this next to last bullet point, maybe they don't have the willingness or the fortitude or the perseverance to deal with a trust situation. And also, we have to be concerned about what is their compensation and make sure that they are adequately compensated, but also to make sure that they are following guidelines about not taking compensation that is really not authorized. So this is what I want you to be thinking about, that it's not just the idea of getting the right choices in your mind. it's really the right, and not just educating your potential trustees, which is a big issue, but it's also just making sure that you understand, again, that no trustee has to serve. They're not obligated to serve. And a wonderful thing that I think you can do, but you have to get used to the idea, is you have to understand that you can have flexibility, opportunity, and revisions over time to appoint and design who your trustees are. And if one of them does not serve or refuses to serve or resigns, that you have the flexibility to continue and your trust does not have to petition a court. Now at Elville & Associates, we do have a division. It is called our Waypoint Fiduciary Services, LLC. And this is our trust group. We actually are not a trust company, but we serve as trustee for many trusts. And we are an alternative that fits for some people. So we want you to know that we are here. We are here to help. So just know that you do have choices with regard to at least Elville & Associates and other professionals, again, that are on this webinar. Their broker dealers and other organizations can very well and probably do have trust organizations. And so we are not appropriate for everyone, but we are here to counsel you about our services as well. And as I wrap up now, and Jeff, we're only about 2 minutes past 11. I think we really did have till 11:30, but we know a lot of people have a lot of holiday activities to do, so we're going to start wrapping up. We encourage you to ask questions, expect answers. We expect that you will come and just, let us help you. But we want you to relax if you do come. We want to really look at all your documents, to really answer all your questions, talk to your advisors, help you get a team of advisors if you don't have a team, which we strongly recommend. But understand that if you do come and consult with us here at Elville & Associates, there is nothing to fear. It's an attorney-client relationship when you are talking with us, even if it's just a first meeting and you don't move forward with us or engage us, you still have an attorney-client relationship, and that's true with any attorney. So there's nothing to fear. We want to give you the time to think, whatever your specific questions are, whatever your design questions are. And we do have high-tech approaches here at Elville & Associates. We're going to illustrate things for you. We're going to streamline things for you and educate you. And we have a whole library of educational materials, and we have connections with attorneys in other states and other resources if we need to resort to those. So I thank everybody for your time and attention here on a Friday the 13th. I wish you a happy holiday season ahead and a happy new year. This is our last webinar of the year, and also for taking your time on a Friday when you could be doing something else. God bless and have a wonderful holiday season. Jeff, I'm going to turn it back to you.
Thank you, Steve. Well said, and thanks for a great presentation about a really important topic. We've got a few questions. Let's go ahead and answer
great.
those. Thank you so much for the questions, and some good ones here. A trust protector, AKA a trust watchdog, question mark, and can a trust protector be named in a letter of wishes or intent?
Well, thank you for that really, really wonderful question. That is really a fantastic question. I have never had anybody ask me a question about a trust protector relating to their letter of wishes, which is a brilliant thought. So yes, the trust protector is a person who has this fiduciary duty, but it's not a duty to monitor. So if you think about it, a trust protector, no person can be tasked with monitoring another person or a trustee. Or the beneficiary of a trust. But the trust protector does have fiduciary duty to when they are informed that there is an issue. And that's why the discussion, let's say an attorney-client relationship discussion, that's why that discussion has to involve how would a trust protector be kept informed, or how does the trust protector keep themselves informed? And this is one of the challenges of once a trust protector knows there's an issue, they do have a fiduciary duty to act. So that's number one. Number two, about the second question, yes, you would probably want to, in your documents, you would want to be proactive to either name a trust protector or to name a surrogate person, like an appointer, a person who is tasked to appoint a trust protector if one is needed in the future. So as long as you have a mechanism like that, you're on the right track. And if you, depending on what approach you take to that appointment, your letter of wishes talking about who the potential candidates are for trust protector or the kinds of persons you would want to be considered as a trust protector in the future, that is a wonderful idea. Even though the letter of wishes is not enforceable, so to speak, it is an informal thing. I think that is really a great idea. So thank you for that.
Okay. All right, next question. Steve, I never thought I'd use my 8 years of French in the presentation here, but there is a term here. And the question is there a CSDK trust or aforementioned silent trust established upon a child birth using their social security number?
Well, thank you for that. And that's a great twist. I wish my French was much better, by the way. I wish I had a lot more years of it. Well, if I understand your question at all, and I think I do, I don't think there is a statutory trust created. If I'm hearing you correctly, and maybe you can clarify your question a little bit either now or later, but there isn't a statutory trust created that I'm aware of. So in other words, if there was money that came into the name of a young child, that child would have to have a guardianship. So I'm not aware of a statutory type trust. Now, there are custodial arrangements. I may be misunderstanding your question. I don't know. There are custodial arrangements that are created. But if I heard that question right, if there was a newborn child and no trust was created for that child, and then that child came into possession of money, I'm not aware of a statutorily created trust unless that child is disabled. So, Jeff, I don't know if I heard that question correctly or answered it, but that's the best I can do, I think.
Okay, thank you. One more. And can a corporate trustee be a law firm?
Thank you very much for that question. Well, a corporate trustee by definition is usually a corporation that has to be a trust company. So to try to distinguish that in the best way I can, a corporate trustee in the way that we're describing it would be a company who is actually capitalized and registered as a trust company in a state, whether that's Maryland or another state. So a law firm, I guess certain lawyers could create a trust company. There's not a lot of trust companies in Maryland due to the capitalization requirements. But I think that if a law firm, or let's be more specific, a lawyer, an attorney, were acting as trustee, they would not be a corporate trustee. They would just be an individual independent trustee. So we have corporations that can actually act as trustees because they are trust companies. And then there are independent people who can act as trustees, for example, lawyers. So I hope that helps.
Okay, great. Thank you, Steve. So now's a great time. Any last questions? Go ahead and get those in to me, please. And we'll talk about 2025. Wow. I remember January 3rd saying, welcome to 2024 and our webinar series. And here we are, the last one. We're going to go into January 8th with Steve for estate planning and elder law essentials. And then on January 15th, we have a very special guest presenter in Victoria Hathaway, who is a wonderful realtor at the Bob Lucido team, and Keller Williams, and also the leader of their Silver group. She's very involved in Howard County. Going to be talking about pocket listings in real estate. What are they and how can they help or hurt when selling your property? So it should be an interesting new discussion for our webinar series. And as always, I'll be sending out the links for today, the slides. I'll send out the letter of wishes and some other information for you that should be helpful in some follow-up. And really want to thank you for your support of our webinar series and your relationship with Elville & Associates over 2024 and the years before, and look forward to seeing you again in 2025. So always reach out to Steve and me with any questions, and we'll see you again soon, and hope you have a really happy holiday.